Okay, this is a little video cast that I've done for LM308. I normally do it as a podcast with just audio, but as I've got a new webcam, I thought I'd try that out, see how it works. So anyway, I'll use this opportunity just to go over a few stories from the media over the last few days, last week or so, that are relevant to media law, information law. So first off, I've got a story here from CNET News, which was published today, 23rd of March 2009, and this talks about a possible indication of how the new administration in the United States, the Obama administration, may be approaching copyright law, particularly to do with the entertainment industry. The last few years in the States have seen some fairly rigorous pursuing of copyright infringers, particularly people that download copyrighted content illegally over the internet. And the music industry in particular, their trade body, the Recording Industry Association of America, the RIAA, has been very active in various ways in pursuing people they believe have downloaded music illegally. It looks like maybe the Obama administration is going to follow the line set by the Bush administration, and there's a case going on at the moment in Massachusetts where the administration have sort of stated that they support the RIAA pursuing of infringers, in particular in this case. And they make the point, they say in their brief, that this is their words, reported by CNET, the harms caused by copyright infringement on the internet include limiting a copyright owner's ability to distribute legal copies of copyrighted works. The public in turn suffers from lost jobs and wages, lost tax revenue, and higher prices for honest purchasers of copyrighted works. So they seem to be following a fairly established line there, that it's about protecting the financial interests of the people creating the music, but also enforcing copyright legislation. According to this article anyway, the people behind it would actually has benefits for broader society in terms of increasing jobs, raising tax revenues, etc., etc. So that's maybe the direction of how copyright law may be pursued or followed over the next few years in the States. Back to England, there was headline sort of news today really on the radio and in newspapers today, Monday the 23rd, about a bit of research that's been done by the Joseph Rowntree Reform Trust, where they've looked at or tried to measure Data Protection Act infringements by public sector databases, so big databases and small ones that are run by the public sector. They claim that a number of them, quite a large proportion, perhaps a quarter, actually are illegal under data protection legislation and under the Human Rights Act, which, if true, is quite a serious accusation. The government have rebutted it, saying that the report produced by the Joseph Rowntree Reform Trust contains no substantive evidence on which to base its conclusions, so the government would disagree with them. But it's interesting, in the BBC News, and this you can click through to these original stories through the blog, the BBC News article says that the government currently spends £16 billion a year, so that's every year at the moment, a year, on databases. And according to this article, according to the BBC, plans to spend a further £105 billion on information technology projects, so not just databases, over the next 5 years. This is according to the Joseph Rowntree Reform Trust. So they're very concerned about this, and they examined 46 public sector systems, and they said that 11 were almost certainly illegal under human rights or data protection laws. And these included some quite high-profile databases. So one of them is the DNA database, used for solving crimes, and also Contact Point, which is a national index of all children in England holding biographical and contact information and noting their relationship with public services. This is quite a controversial database, the Contact Point one, in that it does contain information on well, according to this, all children in England. And there's also another database sort of related in a way called Onset, which is a profiling tool which, according to this article, examines a child's behaviour and social background to identify potential child offenders. And this, in the view of a lot of people, is very disturbing, because not in this article, but I've seen it written elsewhere, they talk about spotting pre-delinquent behaviour as a way of perhaps identifying future criminal behaviour amongst children, and it sort of, to me anyway, smacks a bit of, I don't know if anyone's seen it, the film with Tom Cruise, The Minority Report, which sort of attempts to predict future crimes and try and prevent them from happening, which, you know, potentially very disturbing. But anyway, that's the BBC article. It's also reported in The Guardian this morning, and apart from the 11 that the report claims are probably illegal, they also identify a further 29 that get an amber light, meaning they have significant problems, including being possibly illegal, needing to be shrunk or split. So, big story, data protection, worth following up. Getting to the end now. Not directly related to media information or specifically, but there was another report on the news this morning about, this is based on some research the BBC have done, using the Freedom of Information Act actually to get the information, which is a tool used by a lot of journalists to get information. Anyway, what they found is that an increasing number of trials where a jury is involved, deciding guilt or not, a increasing number of them are not reaching verdicts, or having what's called a hung jury, where they can't make their mind up. And apparently over the last 2 years the number of hung juries has more than doubled, which is a huge increase, and, you know, potentially has implications across a wide area of law in England and Wales, so something to at least be aware of. And then finally there was a story, well, this was reported in the Observer yesterday, Sunday the 22nd of March, but it was also picked up by the Today programme on Radio 4 this morning, and it's about an amendment being put forward to a bill that's going to go to a vote in the House of Commons today, Monday the 23rd of March. It's put forward by a Liberal Democrat MP, Evan Harris, and he's trying to rid the legal system, according to this short little article in the Observer, trying to rid it of the offence of sedition. And I mentioned in my lecture on libel that there is the notion, or there is the concept, or the potential for somebody committing seditious libel. I gave the example of a case from hundreds of years ago where penalties were rather more severe than they are now, but the charge of seditious libel still is possible to be raised against people. And he's putting forward an amendment to a bill that could repeal this crime. And it says here, seditious libel, as opposed to, you know, standard libel, is the act of writing something that brings into hatred or contempt the Queen or her heirs or the government or the Constitution and the justice system, and is punishable by life imprisonment. So it's a bit different to libelling someone in a newspaper, you know, in a fairly standard way. This is to do with actually, you know, in the view of the law when it was first created, threatening the stability of the Constitution, the monarchy, etc., etc. So this Liberal Democrat MP is hoping to repeal that and remove it from the statute books. So we'll see in a few hours, perhaps, how that vote went and whether it was successful. So that's it for this videocast, and I expect I'll be doing one or two more before the exam for this module. Okay, thanks.